morning. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode number 45 of Business SOS. Thank you for listening today. I'd like you to participate in the show. If you have any legal questions you'd like to address for me to address in the show, just please send it to rich@richsierra.com. And if I select your question, I'll address it in the show. I'll send you a free copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for it in your local bookstores as well. Last week, I talked about small claims process, that if you want to file a claim that is in less than $8,000 in controversy, or $8,000 a dispute, you can file it in small claims. And this is one of the few times that I tell you this is something you can do yourself. You do not need an attorney to actually file a small claims action. But you can use an attorney if you want to. And I went over the form, I went to some of the process, and in the show notes of last week's episode, I posted a link to the Palm Beach County website, which is the source that I utilized for last week's show. So today I'm going to talk about what happens if you're in a situation that you lost a case and there's a judgment filed against you. At time it happens, whether it's a credit card debt that perhaps you couldn't pay, and then they filed a lawsuit, sometimes even in small claims, and you got a judgment. So in this particular case, you're going to be getting a judgment, but they also tell you that you need to file what is called a fact information sheet. Today, I'm going to talk about the fact information sheet, what it means, and what information you got to provide to a judgment creditor, and what are the consequences to you if you do not provide information that is required of you. So what is a fact information sheet? Basically, in the judgment, you'll have basically say something you have to pay the judgment creditor, this amount, plus interest annually that is pursuant to the statute. And I said, you have 45 days to comply and provide information, what is called the fact information sheet or form. In Florida, it's 1.977A. That is for personal, and that's what we're going to focus on today. In next week's show, we're going to talk about Form 1.977B, which is for the business. So here, the context of today's episode is going to be if I have a personal judgment against me, and I'm required to provide this information, and an question that I'm often asked, well, do I need to provide it? The answer is yes. So let's start with the form. And to the extent that I can, I'm going to provide a link to this form in my show notes. And if not, you can send me an email. I'm happy to provide it to you. It's a free form. It is pursuant to in the form of the Florida Rules of Civil Procedure. So I can provide this form to you. It's not mine. It's basically the government's. So obviously, you got to provide the first information they want from you is complete information about who you are. Obviously, your full legal name, nickname, aliases, where do you live, mailing address, telephone numbers, your name of the employer, where do you work. This is important because it's likely that if there's a judgment against you, the judgment creditor will try to garnish your wages. And there's certain limitation they can, but there will be a garnishment you can expect that will be sent to your employer to satisfy this debt. Your position or job description, your rate of pay, your average paycheck, if you get paid commissions or bonuses as well, or any other personal income, and you have to provide details of this in additional paper or at the back of the sheet if necessary. So they want to know everything that you are, all sources of income. They want your social security number. You got to provide that to them. Your birth date, your driver's license number, your marital status, and your spouse's name. And you would ask, Rich, why do I need to provide this information? That's kind of personal. Unfortunately, when there's a judgment against you, the judgment creditor will have the ability to get all this information. And the government allows them to have the information and request it from you And this is pursuant to a court order. And later on, I'm going to talk about the consequences of not complying with the court order. They also want to know about your spouse's address if she's not living in the same household. Says it's different. Her social security number, even though if she's not part of that judgment, they're entitled to know this information. Your spouse's employer, your spouse's average paycheck or income, any other family income that you may receive, and that's for personal information. Any other financial information they want to have, it says here, describe all other accounts or investments you may have, including stocks, mutual funds, savings bonds, or annuities, on the back of the sheet or an additional sheet if necessary. So you got to find out where the account is, the account number, who it is, who owns the account, all the information you got to provide. You can also provide perhaps a copy of the statement that will satisfy in providing the information. They also would like to know the name and ages of all your children and addresses if not living with you. And whether or not you have to pay child support or alimony that you're paying. Any other individuals who live with you as well. Who's the head of the household? Whether it's you or the spouse. I'm not sure whether, again, this form is prepared a long time ago, so I'm not sure that's even applicable, but I don't know what that means. So if you ask me, who's the head of the household? But they ask that question. Any checking accounts do you have and account numbers? Saving accounts as well. Any real estate that you have, that you own or you're buying, the address, all the names and the title, if the property has a mortgage, the balance owed, and the monthly payment. All that information you have to provide. You also have to attach a copy of the deed of the mortgage, and you can download that from the public records. You might have a copy from the closing documents, but also if you live, for example, in Miami-Dade, Broward, and any county in Florida, you can go ahead and go to the public records in the county. You can download a copy of that. Or list the legal description of the property in the back of the sheet or an additional sheet if necessary. Also provide the same information on any other property that you own or you're buying. So you're in the process of buying a property, hasn't closed yet, they want to know that information, they're entitled to that. Remember, they give you 45 days to gather all these documents and gather all this information. So it's not something you have to do overnight, but it's something that you're required to provide. Again, these documents are not filed with the court. It's very important to know that. This information is provided to the judgment creditor, whether it's another individual, most likely be an attorney, and then what you do, you file what is called notice of compliance with the court, say I complied with providing the fact information sheet 1.977A to attorney so-and-so. On this day, you filed that with the court and you complied. Now let's talk about vehicles. So for every vehicle that you have, all motor vehicles that you own or you're buying, they want to know the year, make and model, the color, vehicle ID, tag number, mileage, names and the title, the present value if you know it. If you owe money to the car, you want to basically see how much you owe, what is the balance of the loan, the monthly payment. You have to list all other automobiles as well, any other vehicles, such as boats, motorcycles, says bicycles as well, or aircrafts on the back of the sheet or additional sheet if necessary. So you have to include all that information. They ask as well whether you have given, sold, or loaned, transferred any real estate or personal property worth more than $100 to any person in the last year. If the answer is yes, describe the property, the market value, sell price, and give the name and address of the person who received the property. Now, I want to stop here and talk about this a little bit more. This is very important. There's something called the Fraudulent Transfer Act in Florida. And what happens is this, is sometimes people, in the anticipation of knowing they're going to receive a judgment, begin to transfer assets. They begin to, go ahead and start giving cash to a relative, or basically selling property for not market value, just to basically transfer the deed of the property to someone else. Oh, they go ahead and open up another company and then transfer the money from one company to the other, thinking that's going to basically solve the problem. The reality is it's going to actually create more problems. If someone transfers property or assets to someone else, in order to try to avoid creditors, not only then you have a separate cause of action that can be filed against you, but also against that individual that assisted you in accepting those assets, specifically if it was done with intent to avoid creditors. My recommendation is don't do it. But obviously, let me preface by saying that if you're in a situation that you have a judgment against you, you need to seek legal counsel. This is not something that you want to do on your own. You need to meet with an attorney who specializes in representing debtors in state court, because there's some exemptions, and perhaps I'll bring somebody here that can help us with that. And a few episodes back, I actually had Jeff Tromberg here, who's a bankruptcy attorney, and he's someone that gave us guidance about what happens if you file bankruptcy, the protections, the benefits. In a situation, you get a final judgment. So if you're in a situation, you have the judgment against you, don't go crazy, don't panic, get legal advice. Certainly, meeting with a bankruptcy attorney will be helpful to you, because the bankruptcy attorney will tell you, can advise you about how much garnishments, what is the maximum amount of garnishments a creditor can take from your paycheck, what they can or cannot take from you. They can attach it to the liens, and whether or not bankruptcy is an option for you if you're in a situation that you have a final judgment faced against you, which they'll be executed by the judgment creditor. So legal advice here is essential, and it's necessary. It's not something you want to do on your own. But in terms of transferring, this is the reason they ask you these questions, whether or not you have given, sold, or loaned, transferred any real property, $20 or more than $100 in the last year, because then this judgment creditor can go back and try to get that money from them. So just want you to keep that advice, to be careful if you're thinking or know someone who's thinking about, okay, I'm going to go ahead and begin to move things around in order to avoid them. It's going to come out. It's going to come out either through your disclosures, it's going to come out through this deposition that they will ask you questions on their oath. They will be able to come out by looking at your bank statements, which we'll talk now about the documents that you have to provide. So my advice to you is that seek legal advice if you're in a situation that you're actually going to have a judgment against you. So they want to ask you also, does anyone owe you money? And how much money is owed, and who owes you the money? And the reason the money is owed, because then judgment creditor can go ahead and put a lien on those funds to collect and satisfy the judgment. Documents that you'll have to provide: your last pay stub, your last 3 statements for each bank, savings, credit union, or other financial account, all the motor vehicle registration and titles, any deeds of titles to any real property you own or buying, or leases to properties that you're renting, your financial statements, loan applications, or list of assets and liabilities submitted to any person or entity within the last 3 years. So if you apply for any loans in the last 3 years, they want copies of that. Anything you provided to personal loan, list of assets, liabilities, anything you submitted within the last 3 years, they want to know, because at that point, they want to see the difference to what you had back then to what you have now, what you're disclosing. So they want to look for inconsistencies. So whether you're saying now is consistent to what you said 3 years ago, or there's a change. So that information you have to provide. Your last 2 income tax returns filed. If you don't have them, you can request a transcript. Most likely they'll ask you to sign a document for you to get a transcript from the IRS so they can provide those as well. So after you complete all this information, my recommendation, if you're in a situation like this, is to do a draft first and then do a final. Okay? But also, more importantly, get legal advice. Very, very important. The last part of the page, it says, under penalty of perjury, I swear or affirm that the foregoing answers are true and complete. You sign it, you get it notarized, and all these documents then you send, and I recommend send a certified mail or FedEx or UPS to the judgment creditor, so that way there's a you can track the package, but also keep copies of that. Just send copies, keep the originals. The case gets lost, but at least you have those documents. You can also ask whether or not they can provide these documents in PDF, and then send the form and notarize, and then file the certificate of compliance. This is something that you have to do. And in my example, and actually in the book, I actually talk about anecdote of, a client that got in significant amount of problems for not submitting the fact information sheet. What I find out from judgment debtors, people that have to provide this information, is that they get in trouble. It's not because they cannot pay. They get in problems because they just fail to comply with providing this form. And the example that I provided is that it actually was a business client that there was a judgment against the business, and they're required to provide this form for the business, which I'll talk about next week. And they just didn't provide it in 45 days. Then the attorney filed a motion, to compel, and the judge gave another 20 days, and the client still did not provide that. So the attorney went back to the judge, says, still have not complied with this. So then the judge say, okay, we'll give you another 10 days, but this time if you don't do it, I'll do what is called writ of attachment, that I will put a warrant for your arrest to bring you here and ask you why you have not complied. And if you don't comply, he has the right to lock you up as a penalty for not complying with somebody submitting these forms. We're not talking about payment here. We're talking submitting forms you're required to provide. So, the key here is not let things to escalate. It's not about failure to pay, it's failure to comply with a court order. You don't want to get into that situation. If you're in a situation that you have to provide a fact information sheet to a judgment creditor, my advice to you is to seek legal counsel as soon as possible. Don't wait to the 44th day to get legal counsel. It's just too close. But if that's the day that you get legal counsel, get it. Because if you retain an attorney, the attorney can actually request an extension of time to comply and file it. So we can always ask for extensions as long as they're reasonable to comply. 9 out of 10 times, the attorney is going to say, okay, fine, I'll give you 20 days. Can you provide it to me in 20 days? So the key here is to comply. So this is good for today's episode. If you have any questions about any of these topics, please send me an email at rich@richsierra.com. If you want to learn more about our legal services, my website is floridasmallbusinesslegalcenter.com. We're on Facebook at FSB Legal. We're on youtube.com/@RichardSierra. You can watch this podcast and video as well. We're on X at @Rich_Sierra. We're on Instagram at FSB Legal. You can call us at 1-866-842-5202. Remember that Business SOS, 8 common legal mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores. If you like the show, please follow us. Give us a 5-star review. Certainly appreciate that. It helps other business owners learn more about our services and also learn more about our podcast. Also, subscribe to our YouTube channel. Until next week, this is Rich Sierra. Remember that my goal is to help you succeed.